Yes, Mr. De Cruz.
Well, I hope you don't mind. I've asked Mr. Douglas to sit next to me to assist with any witnesses that I need and the like.
Of course.
Thank you. Well, I'm just going to make a few headline points before I dive into the grounds themselves and our response to those grounds. We absolutely maintain that the anti-suit injunction that RUNSEC sought below, the courts below, and that it continues to seek today is unprecedented. And that is, as I will explain in due course, evident from both the analysis in paragraph 26 of our skeleton, which goes through the relevant cases they rely on, and the discussions in those cases. What RENSEC is seeking, let's be clear, is to prohibit Adorabella and Pepepsia from bringing their RRE claims anywhere. And I will explain in due course why, in relation to ground 2, the LCIA option doesn't work and is irrelevant. And that obviously has access to justice, very clear access to justice implications. Moreover, what is also unique about this application is that it is directed not against claims brought in Russia against RENSEC, but against third parties. There is, in fact, only one example in the authorities before you, and even that only by reference, of the court granting an anti-suit injunction in a true single forum case such as this, where the effect would have been to prevent, whether it's the claim or the issue in dispute, being adjudicated anywhere. That's Midland Bank and Laker. And your lordships will recall from the summary of that case in Airbus that involved an antitrust claim brought in Texas between two English companies in relation to a loan agreement between the two of them that was governed by English law. So that was why it was overwhelmingly English. And that was a critical factor in the approach that the court took in granting, exceptionally in that case, an anti-suit injunction, notwithstanding it was single forum. Moreover, the claim that RENSEC seeks to injunct in Russia against the RREs is so overwhelmingly Russian. It is a claim brought by Russian and Russian-controlled companies against Russian defendants. It is a tort claim governed by Russian law. It is brought before the Russian courts who have exclusive jurisdiction over that claim and which have seized jurisdiction over that claim. So we say that granting an anti-suit injunction in that context would involve an almost unprecedented breach of comity. It will be startling. So those are our headline points, and let me just dive into the grounds themselves. Subject to what your lordship's preference is, I was actually proposing to take ground 4 first, which is the contractual claim. Seems to us to be the logical way. If there's a contractual and non-contractual basis for an anti-suit injunction, you look at the contract first, and then you look at the vexatious or oppressive gateway next. And indeed, this was how it was put at first instance by RENSEC, although they've turned it around for this appeal. There's no dispute between the parties that when one comes to analyze whether the arbitration agreements in this case or in any analogous case covers third-party claims, one is first and foremost, but first and last, with something in between, considering it from the point of view of conventional contractual interpretation. Clearlake identifies various nuanced factors to have regard to when determining if the parties to the dispute resolution agreement, it could be exclusive jurisdiction clause or arbitration agreements, of course, intended objectively as rational businessmen for that clause to apply to dispute against third parties. One thing to note about Clearlake and indeed Cavendish is that in both those cases, they were dealing not with arbitration clauses, but with exclusive jurisdiction clauses. That does not affect the validity of the factors that were listed in both cases, but it does affect the prominence of two of those factors, which is contractual imbalance. That was the point made in paragraph 82.5 of Cavendish, and submission, a point made in 82.7 of Cavendish. Now, the contractual imbalance point that was being made by Lawrence Rabinowitz QC in Cavendish was simply this, that if you interpret a dispute resolution clause as applying to third parties, what mechanism is there to bind that third party to the relevant dispute resolution process in that agreement? In circumstances where that third party is not a party to the umbrella agreement or the arbitration agreement and would simply be able to say, privity of contract, I'm not bound by this, and I do not accept the jurisdiction of whatever the clause says. So that was the contractual imbalance point. And what Lawrence Rabinowitz said was that does the contract in any way seek to address that? Does it set out any mechanism for ensuring, what he then goes on to say in 82.7, a mode of a method of submitting the third party to the relevant jurisdiction?
You began this by posing a question of interpretation, whether the forum clause is intended to apply to disputes with third parties.
Yes.
But may that not be too broad an interpretation? Isn't the question really whether the clause is intended to apply to claims by the other party to the clause against associated companies of the first party based on joint and several liability for the conduct of the contracting party?
That's obviously a subset of third parties who might be caught by an arbitration agreement. In the analysis of Lawrence Rabinowitz in Cavendish and in Clearlake, and I think also in Donoghue and Stevens, Donoghue and Armco, Lord Scott's comments in paragraph 60 and 61, they were certainly talking about it in a much broader context. But the common principle that they all identified is whoever the third party is, whether it's an affiliate or non-affiliate, it's still necessary to adopt a conventional contractual interpretation approach and say, did the parties rationally intend that this clause should cover the claim that has transpired?
Yes.
Now, that might well be a claim against an associate, and it might well be that there are terms of the contract which address the position of associates, as indeed was the case in Mr. Justice Tier's decision in Dell.
Yes, well, does it apply to the claim which has transpired is
Yes.
perhaps a more promising way of framing the question, because if you simply ask the general question which you began with, does it apply to disputes against third parties? Well, obviously not, if the third parties have got nothing to do with either party or the matters which are to be arbitrated.
Yes.
So a certain amount may come down to how you ask the question.
Yes. So, addressing your point, my lord, you do have situations, and the Dell situation was one where there is a contract between A and B, and the contract provides for some of the services that A has promised to provide to B to be provided by affiliates or subsidiaries. That was exactly the position in Dell and IBM. And then if there's references, as there was in that case, in the contract to the services to be provided by the associates and the affiliates, that may be a factor to take into account, a relevant factor to take into account when interpreting whether or not the dispute resolution clause would in due course cover disputes with those associates and those affiliates. In the Dell case, there were in fact additional terms which pointed in that direction. One of those additional terms was a clause which specifically said that any claims brought against Dell, I think it was, yes, any claims brought against Dell or its associates had to be brought within 1 year. There was a 1 year limitation period in the contract. And what Mr. Justice Tier found was that was a powerful indication in itself, because it was a specific reference to claims against the affiliates, that the separate jurisdiction clause, which didn't refer to the affiliates, was intended to cover such claims. So the main point I'm making is that as a matter of contractual interpretation, yes, certainly look beyond the arbitration clause or the jurisdiction clause, have regard to the actual claim that has arisen against the third party, see within the terms of the contract and the terms of the jurisdiction clause whether there is any reference to such claims against that third party, either directly or indirectly. And these are all pointers or indicators one way or the other. What we have in this case, in these ICEs, is of course no reference to any services covered by the ICEs being provided by the RRE affiliates. Well, two of them are now no longer affiliates, but I'll call them affiliates if I may. So it can't be said that there's anything in that contract, in the terms of the contract, that ever anticipated a dispute with those RRE affiliates. So there's just nothing there that indicates that. But that's just one of the indicators. The point that both Cavendish and Clearlake make, the main point, the first point, is that the starting position is you would expect to see clear wording to indicate that the jurisdiction clause was intended to cover third-party claims. Or to be more specific, this third-party claim, this claim against the RRE affiliates for our purposes. And there is absolutely nothing, either in clause 43.2 of the ICES or anywhere else in that agreement that could be said to be clear wording of an intention to cover claims against the RREs. And it is striking that both in their skeleton argument and indeed in oral submissions, that your lordships were not taken to anything within the agreement itself, any wording within the agreement that points towards an intention to cover RRE claims. It's all about the unrestricted position of potential claims against third parties that would involve subsidiary liability or contribution claims against RENSEC. That goes nowhere near meeting the conventional contractual interpretation approach, and the starting point in Cavendish. Is there any clear wording to show that it's supposed to cover third-party claims? Now, RENSEC's case on this is based almost entirely on what Lord Scott said in Donoghue and Armco, paragraph 61 to 62. And then the reference to that in Clearlake by Andrew Burroughs QC as he then was. The first point to note about Lord Scott's comments is that was another case which involved an exclusive jurisdiction clause and not an arbitration agreement. And I do say that there is an important difference for present purposes between the two. What Lord Scott was concerned with when he was analysing the position in paragraph 61 and 62 was forum fragmentation. But with respect, that does not apply and cannot apply, at least with the same force, in an arbitration, in case of an arbitration agreement, because forum fragmentation is a fact of life that the parties to an arbitration agreement take on as a risk when they decide to include that sort of clause in their contract for privity of contract reasons that we're all familiar with. There is no necessary or proper party gateway that applies in arbitration that could force a claim against force a third party rather into a dispute. And I use the word force by reference to 21.110 of the LCIA rules that we'll come to in a moment. But there is no mechanism for forcing a third party into arbitration. And so when parties agree to use an arbitration clause in their contract, they're accepting that tort claims against third parties will necessarily go elsewhere and there will be parallel proceedings. So that's the first point about Lord Scott's comments. But if your lordship, when your lordship has, lordships have a moment to look at the context of it, you will see that the first comment that Lord Scott makes is a very conventional one. I think it's actually at the top of, it's the beginning of paragraph 60. It's a very conventional one. The point is one of construction. He then goes on in those paragraphs to look at the specific clause that arose in that case and the wording of that clause. Would your lordship like to see that? It's at tab 6. Sorry, not tab 6. Tab 9. And if we go to Lord Scott's comment at 146, paragraph 60, see the point I'm making. So you'll see at the beginning of paragraph 60, top of page 146, the first point he makes, it's a point of construction of the exclusive jurisdiction clause. Then by D, you'll see that he focuses on the wording of the specific jurisdiction clause in front of him, that it was expressed to cover any dispute which may arise out of or in connection with the agreement. And then he develops his analysis from that. He talks about it being expressed in wide terms, etc. So the point I make for the moment is simply that he approached it in conventional terms. He came to the view, and we would especially say wrongly, as other authorities have found, that interpreting that contract and those wording and that wording in that particular context was sufficient to cover tort claims. But can I just ask you also, draw your lordship's attention also to his treatment of RICO claims at paragraph 68, which begins at the bottom of 147 to 148. So the RICO claims are different from the tort claims that arose in Donahue and Armco. And you will see that Lord Scott came to a quite different conclusion in relation to those RICO claims. Obviously governed by US law, and he says, 148B, it cannot, in my opinion, be supposed that in submitting to the exclusive jurisdiction of the English courts, the parties had in mind claims which an English court would have no jurisdiction to entertain. The contractually expressed purpose of the submission to the English courts was to settle any disputes which may arise, etc. How can this language be sensibly thought apt to cover a dispute that the English courts would be jurisdictionally unable to settle, notwithstanding, of course, forum fragmentation? But what we can see from his approach there is, again, he's looking at it from conventional contractual interpretation from a conventional contractual interpretation perspective, standing back and saying, look at the wording of this clause. What would reasonable businessmen in the shoes of the parties have intended of this clause in respect of RICO claims? And on that issue, he came to a negative conclusion. Why? specifically because that would result in the RICO claims having nowhere to go, specifically because of that. And the same analogy therefore applies to an arbitration context. If you interpret an arbitration context, arbitration agreement as covering a third-party claim, and there is no way of forcing the third party into arbitration, then there is nowhere for that third-party claim to go. And applying Lord Scott's reasoning, that is not what reasonable parties could have intended. And I come back to the point that Donoghue and Armco was not an arbitration agreement. I would suggest that if Lord Scott had to consider this or turned his mind to the arbitration scenario, he would have come up to the same conclusion as he has in 68.
You may be right, but at least in principle, there appears to be a difference between a scenario where a court has no jurisdiction. The English court had no jurisdiction, is the example he's giving, and a situation where you could have arbitration, but you choose not to.
Yes.
Those don't seem to me, at least, to be identical scenarios, but you're saying that they are.
Well, this is arbitration in relation to a claim against a party that is not subject to the arbitration agreement.
Yeah.
That's why at the time, of course, that you're contracting, and one's looking at this from that point of view in terms of assessing the party's intention, there is absolutely no clarity of what claims might fall within, what third-party claims might fall within the arbitration agreement, and of course, whether or not that third party would consent to arbitration.
No, I appreciate all of that, but I'm not sure that you get all of that from Lord Scott's dictum.
What I say in relation to it is the logic of the conclusion that Lord Scott reaches at 148C would come to the same, would as a matter of process and consistent process, reach the same point.
Right.
So, of course, Lord Scott's comments were overture, and we've referred, I think, in our skeleton to the criticism that there has been of it, including in Raphael, Crescendo, and Asiana. And if I can give you, I'll give you, if I may, the Raphael, I can give you all the quotes, but the Raphael one, perhaps the most helpful. It's tab 34, paragraph 7.31 at page 768. And if I could ask your lordships to, in due course, look at Asiana, tab 32, paragraph 68 to 71, and 85 to 88, you will find that at pages 646 and 656. And you'll see that in Asiana, the Singapore Court of Appeal were pretty direct in their disagreement of Lord Scott's approach. So applying that briefly to the arbitration agreements themselves, you will see how we put our case in paragraph 47 of our skeleton, and in particular, we address there the 7 clear indicators that His Honour Judge Pelling identified within the ICES as indicating that they were not intended to cover third-party claims. The arbitration agreements at clause 43.2, I should say, were not intended to cover third-party claims. Perhaps it is appropriate, because your lordships haven't looked at it yet, to have a look at clause 43.2 very quickly. You'll find that at tab 8, tab 8, page 90 of the core bundle. 90 is the first page, and it's 1 to 8. see the relevant clause. Now, the first thing I draw your lordship's attention to is that clause 43 obviously has four subclauses to it, and they cover the dispute resolution process and governing law. And therefore, without pausing there for a moment, we say it must, as a matter of logic and contractual interpretation, be necessary to read each of these subclauses closely in connection with the others in these four clauses. So the first one deals with the governing law situation, non-contractual and contractual obligations governed by English law. And then the critical arbitration agreement at 43.2, if any dispute should arise in relation to the customer document package, and it cannot be resolved within 30 business days, by negotiation between the parties, such dispute shall be referred to LCIA arbitration. Now, there are a few points to take from this. What is immediately apparent from that first sentence is that the focus of this clause, what the parties are giving attention to, is disputes between the parties. Hence the reference to the parties in the second line. The second point is the precondition of negotiation between them as the gateway into arbitration. So there's an agreement to arbitrate, but there's a step that needs to be taken before that right to arbitrate and obligation to arbitrate kicks in, and that is negotiations between the parties over the course of 30 business days. It follows from that, as a matter of immediate logic, that this clause, without going any further, cannot apply to disputes between third parties because, of course, the parties are not entitled to negotiate disputes between themselves, disputes that either of them may have with a third party.
Why not?
Because they cannot bind the third party to negotiation, to anything that is agreed during the course of negotiations.
Negotiation isn't binding anyway, isn't it? It says you shall negotiate.
Yes.
The party should negotiate 30 days.
Yes.
And then there can be an arbitration.
Yes. But I'll answer that in this way. What is the purpose of the requirement to negotiate? It is to give the parties, it is to provide a period during which it may be possible to settle the dispute. That's what it's there for. That cannot work if the parties are negotiating a dispute that involves a third party that's not involved in the negotiation.
Well, I say again, why not? Why can't parties have negotiations about a potential claim against a third party?
Because they would have no authority to do so. At least not direct authority. Of course, there's always a potential scenario in which a hypothetical third party, unknowable at the time of the agreement was entered into, may in the future authorize one of the parties to negotiate on their behalf for the purpose of meeting this precondition. But that's clearly not what is intended in my submission. Stepping back and asking, as a matter of from the point of view of a reasonable businessman, what were the parties thinking of when they were referring to negotiation between the parties of a dispute? Whilst in theory, of course, anything is possible, the logical commercial view is they were thinking about disputes between themselves. Now,
prima facie, I mean, the whole
Yes.
arbitration clause is primarily directed at disputes between the parties.
yes, absolutely, and we can see that also in the last sentence, which refers to the position of an award. An award rendered shall be final and binding on both parties. No reference there to a third party. Now, what we say is significant about that is so we see at the beginning and at the end of that clause, that agreement, that arbitration agreement, that the parties are, as a clear indicator, focusing on the position as between them in relation to future disputes.
But your submissions are concerned with third parties
Yes.
in general. We're,
Yes.
we're concerned with a very specific kind of third party,
Yes.
which is a third party who is or was at the time of this agreement
Yes.
closely associated
Yes.
with one of the parties,
Yes.
and who is alleged to have joint liability with the parties. Now, why shouldn't the two parties to the agreement cover any negotiation about that liability? Sorry, cover any issue about that liability, that associate's liability, in the negotiations they have. I mean, those are obligations which arise in connection with the agreement
Yes.
in clause 43.1, and it is a dispute in relation to the customer document pack within 43.2, isn't it?
Oh, in broad terms, one could view it in that way. But the issue is that objectively, from a commercial point of view, what the parties are likely to have intended by using the specific phrase that they did. And one of the
If you ask it
indicators.
the other way round, was it the party's intention that while they are undergoing this 30 business days of negotiation, one of the parties can just go off and sue the other party's associates?
I'm sorry, I missed the beginning of that question.
If you ask the question the other way round,
Yes.
and say, was it contemplated by the parties, or was it intended by the parties, that while the 30 business days of negotiation, as required by the clause, between the immediate parties are going on, one of them can go off and sue the other party's associates in respect of the very same matter which is supposed to be being negotiated?
Well, the answer to one of the answers to that, I would submit, my lord, is coming back to the starting point at Clear Lake. If you're intending any of this type of arrangement to apply to claims against third parties, if you're intending to bring them exceptionally into a dispute resolution mechanism in a contract to which they are not a party, you would expect clear words to be set out addressing that. The other point I would make, and it's another issue, it's another of the factors that's raised in Cavendish and endorsed in Clear Lake, is does the agreement refer elsewhere to third parties? And if it does, that is an indicator that the absence of any reference to such third parties in the arbitration agreement is an indicator, that is a further indicator that the arbitration agreement, dispute resolution agreement, was not intended to apply either to those third parties or to any other third parties. And there is a plethora of references in this agreement to the position of those other than the parties. And I will give you an example. For example, an example would be paragraph clause 29.3, which you will see on page 121. This is indemnities and warranties that are given, representations I should say, and warranties that are given respectively by Perpetua and Adorabella. And if you look at number 3 and number 4, Roman numeral 3 it relates to the ultimate beneficial owners of those companies and directors, officers, etc. And it talks about adequate disclosure of this fact has been made to Renaissance. Where any of those listed there or underlying clients for whom you might be using any services here under is a PEP. So it's really a sanctions type of situation. Adequate disclosure of this fact has been made to Renaissance. And then in 4, neither you or any of your associates or any of directors, officers, employees, agents, etc., is subject to any sanctions. So that's one reference to associates. Then,
Can I ask, is associate is with a capital A and so is associated firm?
yes,
Where are those definitions?
towards the back. you will find them, and it's certainly a relevant point, page 132. Unusually in this agreement, the definitions come at the end. So this is on internal page 43 of the document. But you will see there is a reference to associate or associated firms. It gives a reference, it gives a definition there, the most directly in relation to Renaissance at Roman numeral 1. And cut a long story short, it doesn't cover the affiliates. Sorry, it doesn't cover the RRE affiliates, I should say.
Does it have to be controlled by Renaissance Financial Holdings?
I think it's, we looked at this in some detail. I think, let's have a look. Yes, it's got to be with respect to Renaissance or the immediate company, Renaissance Financial Holdings Limited.
And an entity which at any point in time is controlled by
Yes.
Renaissance Financial Holdings Limited.
Yeah.
So you're saying the RREs have never been controlled by Renaissance Financial Holdings Limited?
Yeah, we can come up with a graph in due course, but we have looked at this before. It's never been said that they follow. It's never been said against us that it falls in this definition. But the reason why you have this definition of associate or associated firm is because there are, as I said, several references to associates and associated firms, including because, in some respects, and I'm trying to find the reference to this, some of the services that are the subject that are obligations of Renaissance are stated in this agreement to be ones that are deliverable by its associates. I'll ask Mr. Douglas to get some references to that, but also relevance, whilst he's doing that, is clause 26 on page 119, which is the set-off provision. And you see there that it says Renaissance or any associate of Renaissance, capital A, may but is not obliged without prior notice to you, set off any obligation owing by you or any of you, of your associates of Renaissance or any associate of Renaissance, etc. And it goes on. So there's a specific set-off provision here we see that the parties have very, very carefully agreed should apply not just to Renaissance, but any associate of Renaissance. The other point, just pausing there, is the detail of this agreement. This is a very complex, carefully negotiated, substantial agreement. And so that in itself makes it even more difficult to imagine that the arbitration clause at 43.2 intended to be applied to third parties, but only by implication. By oversight, if you like, the parties didn't make a specific reference to that. But all these references to associates, what that shows separately is that the parties, on a number of occasions, identified specific aspects in which the ICEs would apply to associates, and yet did not do that in the arbitration clause. It is difficult to imagine, as I said, that's just an oversight. And that's one of the factors identified in Cavendish and Clearlake as a relevant point to take into account.
Mr. Ducruz, the burden, as I understood it, of Mr. Gilmore's submissions this morning was that there may not be any positive obligation
Yes.
to include disputes concerning third parties in the arbitration process.
Yes.
But he submits that there is in this contract a negative obligation, which is imposed on the parties, not on the third parties,
Yes.
but on the parties to the contract,
Yes.
not to do something
Yes.
vis-a-vis third parties,
Yes.
which would circumvent the arbitration process between the parties.
Yes.
That I think is the main point that's made against you.
So my answer, may I?
Yeah.
My answer to that, my lord, is there's no difference in principle between positive or negative obligation. Whatever the obligation, positive or negative, if it was intended to apply to third-party claims, there was still an expectation that it would be set out clearly and expressly. The principle in Cavendish and Clearlake about that as being the starting point applies both to positive obligations and negative obligations. The issue is whether the arbitration agreement applies to third-party claims. Applies in a positive sense or applies in a negative sense. It matters neither here nor there. Does it apply to third-party claims? That's the simple answer.
I think does that amount to this submission? That may be the bargain they wish now that they had contracted, but it's not the one they did in fact agree.
Of course it is. That's right. This is an attempt to say, well, look, with hindsight, we wish we had done this. But if they didn't, even with hindsight, seek to incorporate issues that related to associates of Renaissance when they entered into this contract, notwithstanding all of the references to associates of Renaissance in the contract, to suggest that nevertheless they intended this arbitration agreement to apply for Lord Justice Mayles to the RRE claims specifically is entirely far-fetched. And is a classic case of trying to rewrite the agreement years after the event with hindsight.
Okay. Leaving aside for a moment the jurisdictional issues, foreign jurisdictional issues, rather in a case like this, if, say, a simple domestic arbitration arrangement where a party, to avoid an arbitration clause, rather than starting arbitration proceedings against their counterparty, instead commences court proceedings, alleging that the parent of the counterparty induced its subsidiary to breach the contract.
Yes.
In other words, a tortious claim.
Yes.
It's exactly the same claim. It's a ancillary claim, derivative claim.
Yeah.
There must be English authorities on whether or not the court would, in certain circumstances, grant a stay of those proceedings on the basis that they were covered by the arbitration.
Not beyond, my lord, the type of discussion that there was or analysis that there was in Dell and IBM that Mr. Justice Tier undertook. If you look at Dell and IBM, what occurred there was that it's, I think, quite similar in certain respects. IBM, I think this is the right way around, IBM agreed to distribute some Dell products. Or it could be the other way around. I think it's Dell might have agreed to distribute IBM products. And the agreement said that that distribution could be pursued or could be delivered through Dell or its subsidiaries or affiliates. In fact, it identified two specific subsidiaries or affiliates. Then there was this additional term in the agreement which said that any claims against Dell or its affiliate subsidiaries had to be brought within 1 year. It was a totality of that. It was looking at the context of the contract that persuaded Mr. Justice Tier to say, yes, exceptionally, it does apply to an associated company. But you have to have something of that kind. You have to have some kind of indication within the contract, rather than this freestanding rubric of some sort of tort claim in the future against who knows who, to extend an arbitration agreement to a third party. Or to use Lord Justice Mayles' analogy, for our purposes, you have to say, did the parties intend this arbitration clause to cover future claims against the RRE affiliates of a tort nature?
There are two separate things, aren't there? One is whether, if you formulate it as you just have, the arbitration clause applies to enable the claims to be arbitrated. The other is whether there is a negative promise not to sue an associated party for conduct which is really the conduct of the party to the clause. And if you put it in that latter way, if you, Renaissance, are not giving us our money back, so that we could arbitrate a claim against you to see if you're liable or not, are we entitled to say we're not going to bother to do that, we're just going to sue one of your associated companies and say that they're jointly liable? And if you ask that question, I thought it's pretty clear what the parties would have intended.
Well,
And that doesn't...
that I would respectfully submit is rewriting the contract. That is the benefit of hindsight. They weren't addressing their mind to that, and if they were intending in any way to apply it to any sort of third-party claim, what Clear Lake and Cavendish makes it clear, make abundantly clear, is starting point is you expect clear language to that effect.
I suppose another way of looking at it is that if the language does not cover that, because the parties haven't thought about it, and indeed how could they have thought about it when I think Article 248 and all the rest of it probably didn't exist at the time of the contract, then it is such a near miss that it gives force to the vexatious and oppressive argument. The two dual points are perhaps related in that sort of way.
Well, I think stepping back, what's lurking in the background is it fair for a party to sue, party to an arbitration agreement, I should say, is it fair for a party to an arbitration agreement to sue a third party in a state court in circumstances where that third party, where the issues in dispute may overlap with the issues in dispute in the arbitration between the contracting parties, or, cutting to the chase here, where the third party being sued in the state courts would join the other contracting party as a contributing party? And the answer to that, very directly, is that is the risk that you take when you include an arbitration clause. And that is precisely the position that the Court of Appeal in Singapore took in ASEANA. I'd ask your Lordship to look at the concluding paragraphs in ASEANA. I think it's the last 2 or 3 paragraphs. The court specifically said that there was nothing wrong in ASEANA pursuing a claim against the director of GG, I think it is, in Korean proceedings, whilst there was, in a related dispute, whilst there was an arbitration between ASEANA and GG, even though that gave rise to duplicate, to overriding issues, and I think also contributory, the danger of contribution proceedings. That is simply an incidence of arbitration. It is the risk you take when you choose, rather than a state court dispute resolution clause, an arbitration clause. And you can't complain thereafter if the privity of contract restrictions that we're all familiar with in arbitration kicks in. The way you do that is to make express provision in your contract to avoid that danger.
I suppose the irony in this case is that here in England, your side is very insistent on privity of contract and different corporate personalities, whereas in Russia, as far as you're concerned, they're all the same.
I don't represent them in Russia.
Anyway.
Now, Mr. De Cruz,
Yes.
I keep an eye on the clock.
Yes,
You've
thank
got 4 grounds. You're on ground 1 at the moment. Sorry, ground 4 at the moment. And you've got your additional points as well. So it's not for me to tell you how to structure your submissions, but I know you'll bear that in mind.
I've been looking at the clock. I'm not going to say more, my lords, about ground 4 because we've also addressed it. I think in reasonably clearly and in detail in our skeleton.
You have. Yes.
I rely fully on that. So I will leave it. Just want to make sure that I've not lost anything important. No, I'll leave it at that, and I'll move now to grounds 1 to 3. And here now we are focusing on vexatious or oppressive in relation to each of those 3 grounds. you've seen what we say about the general principles in relation to vexatious or oppressive. But can I just highlight them? Of course, comity is the most important. It's what looms over the entire vexatious or oppressive gateway. Then there's the issue of whether or not the English court has a sufficient interest. I'll come to what we say that means in interfering with a foreign proceeding through an ASI. There also has to be a legitimate interest of the ASI claimant in seeking and that sort of injunction. And assuming that the ASI claimant has a legitimate interest, it's only then that your lordships should be considering whether or not the foreign claim is vexatious or oppressive. And even if you get to that point, there is still the discretion that your lordships need to exercise.
Well,
So-
sorry, I'm sorry to interrupt you, Mr. De Cruz. You're addressing us immediately as if we were the first instance court, but actually we're an appellate court, and at least initially, the task for us is to decide whether the judge below was wrong. Yeah,
Well, yes, say for this, my lord. My learned friend said that if he wins on ground one,
yes,
he wins.
yes.
That's
but-
not right.
Ah,
He has to win on ground, even if he wins on ground one, i.e. to say that there is no threshold forum issue, and I'll come to that in a moment, he still has to go on to say, had the judge applied, had the judge accepted that there was no threshold forum issue, he would have found that the RRE claims were vexatious or oppressive. My learned friend has to do that, and that's what he seeks to do in ground three. That's exactly what ground three is about. So, forgive me, but what I'm trying to do is really to identify points which will be relevant to ground three
I see.
as an introduction
Right.
to dealing with grounds 1, 2, and 3.
I see.
I'm sorry if that wasn't clear. Yeah, so we deal with comity in paragraph 11 to 10 to 11 and what that means. And I'll ask your lordships to have a look at that. The one point that we would particularly stress from what we say there is the principle that foreign courts are entitled to give effect to their own legislation, even if they can conflict with the solution reached by the English courts. That's also referred to in Raphael at paragraph 4.92. And for all these reasons, even before we get to a single forum situation, the antecedent injunctions have been referred to as exceptional and rare. Now, can I come to sufficient interest and just the law on this? Because that is the gateway into vexatious or oppressive. And just as a matter of general principle, common ground that there needs to be a sufficient interest. My learned friend says, well, what about connection? There needs to be a sufficient connection as well. It's not sufficient interest plus connection. It is sufficient interest and sufficient connection that justifies an antecedent injunction in a vexatious or oppressive context. Now, in alternative forum cases, the sufficient context and the sufficient interest is that the English court, or here the arbitration, is the natural forum. So assuming for a moment that LCIA works, which we say it doesn't, what RENSEC has to show is that that will be the natural forum for the case. And we say they can't do that because this is the RRE claims are an overwhelmingly Russian claim. It's not possible to describe those as an English claim, not just because there is a transaction standing at the back of it, which is English law governed. I'll come to that in a moment. In an anti-suit injunction case, in a single forum case, the ramifications of granting an anti-suit injunction are self-evident. It's the access to justice point, and that's why it's referred to as exceptional, and indeed, Raphael says it's drastic. Now, Raphael also identifies three categories of potential categories of anti-suit injunctions being granted in single forum cases, and they are if the claim is bound to fail, the foreign claim is bound to fail, if the dispute between the parties, it's not the contract, it's the dispute between the parties is overwhelmingly English. That's very important. You'll see that also referred to in Raphael at 34, paragraph 4.82. Again, it's not enough to say that here we have a contract in the background, it's got English law, that is the gateway to a single forum anti-suit injunction. It goes nowhere near demonstrating the sufficient connection that's required, because this dispute is overwhelmingly Russian. And then the third situation, which I think is the real battleground here, is protection of the English court's jurisdiction or policy. Now, as I said at the very beginning of my submissions, please do have a look at paragraph 26 of our skeleton, because that deals with the string of new cases that RENSEC is now relying on to say they fall within, or they provide support for the injunction that it is now seeking. And we have gone through in detail, efficiently I hope, but with sufficient detail to explain why they are absolutely not on point. They are absolutely not precedents for what is being sought today. I'll have a quick look at that. You'll see. So it's 11 subparagraphs. We go through each of the cases. You'll see that Airbus alternative forum case, Barclays Bank and Holman alternative forum case, Deutsche Bank alternative forum case, Midgard straight contractual alternative forum case, Starries alternative forum case, JSA, BNP and Paribas. That was an anti-suit injunction against a third party, not in relation to a third party claim, against a third party that was seeking to invalidate, I think it was a guarantee agreement between the contracting parties that was the subject of an arbitration, I think, an existing arbitration process. So it was a question of collusion that interfered with an existing arbitration. It was not an anti-suit injunction against a claim by a contracting party against a third party. Now, Ms. Lowenstein seems to dismiss that by saying, well, that's just detail. It's not detail. It's a very specific difference to show that that case is not our case. Crescendo, alternative forum. Emmett, contractual alternative forum. In Emmett, what happened was that an anti-suit injunction was granted to prevent an issue in the arbitration being relitigated. Now, that's alternative forum because the issue in question had a forum to go to, and it had already been to that forum, being the arbitration. So it wasn't a situation where there was nowhere to go, access to justice, immediate access to justice difficulty. Softcom Bank, contractual alternative situation. And then Asiana is actually probably the most relevant for our purposes, because there, as I mentioned, the Singapore Court of Appeal dismissed an anti-suit injunction that had been granted at first instance level against the claim brought against the director by one of the contracting parties in Korea. And one of the reasons why, last two paragraphs, that they did that was they came to the conclusion there was nothing vexatious in Asiana choosing to go to Korea where it believed it had a better chance of success against the director, even though that might have involved contributory proceedings and duplicative proceedings as far as the other contracting party is concerned. That is no different to my clients choosing to go to Russia and bring the RRE claims in Russia, because this Russian law claim will be heard by the Russian court applying the proper law, and they have a better chance of success. That is a legitimate advantage, not an illegitimate advantage.
But what that does illustrate, does it, that there's no objection as a matter of law to having an ASI? even in a single forum case.
I accept that, yes. So ground one.
Yeah.
Ground one, I do accept that the jurisdiction does exist.
So the judge is wrong.
I accept that the judge is wrong, but I would say in defending the judge and defending myself somewhat, that the argument that you've heard today was absolutely not developed. It was asserted literally in bare terms. If you look at the transcript, what the judge was told is there is a single forum principle. Therefore, you have jurisdiction, and that's it. I'll return to it in reply, and it was never developed. And none of these authorities were before the judge. So none of the principles, the specific principles that apply to single forum cases were ever put before him. Sufficient interest, etc., etc. They just weren't put before him. So, did he get it wrong? He wasn't at fault. I put it that way. He dealt with the arguments that were before him. He identified that there was a threshold issue, and we accept there is no per se threshold issue. But we say that's not enough because you still have to show that you meet the very high threshold for single forum anti-suit injunction cases.
Yeah.
That's ground three. They don't do that.
Yeah. No, can we just pause for a moment and see where that leaves us? We have before us an appeal advanced on the basis of 4 grounds for which permission has been granted to pursue this substantive hearing.
Yes.
And in relation to ground 1, you now accept that the judge was wrong, and therefore he erred in law in the approach which he took.
Yes.
Leave aside ground 4 for the moment, which is the contractual basis for an ASI. Let's just focus for a moment on the non-contractual basis for an ASI. So you accept that the judge was wrong in the legal approach that he took. Right? Does it follow that ground 2 becomes academic because it's only advanced by Mr. Lowenstein as an alternative if he was wrong on ground 1?
Yes, if that's the way he's putting it.
All right.
Because the other way of putting it, and he'd be wrong to put it this way, is if we're in alternative forum territory, there's a slightly different test and it's easier.
Okay. Well, I don't want to preclude you from making any arguments that you think it's important to your client to make. Okay. I just want to see conceptually where we're going now.
Right.
Perhaps the more important question may be this. That since you concede that the judge was wrong as averred under ground 1, does it follow that this court has to do the exercise for itself, and therefore ground 3 in effect becomes, what should this court now do? Particularly in relation to the vexatious and oppressive limb of the jurisdiction. Is that what it now amounts to?
Yes, I think there is case law to that effect. Right. If I'm trying to think what it is, but to the effect that if the Court of Appeal comes to a conclusion that the judge below exercises discretion on a legally erroneous basis, then the discretion has to be reconsidered.
Precisely. Yeah. And is that what you, effectively, is that what you are inviting us to do, but in a different way from what the appellant invites us to conclude?
Well, probably inviting you is a bit too high putting it, but that's where we are. I think that's where we are.
That's very helpful.
And as I said, I think the battleground is ground 3. Yeah. To be honest.
Yeah. No, that's been very helpful, and I think that does help to set the framework for what I hope will be submissions which we're able to conclude in the next hour.
Yes. Now, within that context, that specific context of the discussion you and I have, I'm actually proposing to jump straight to ground 3.
Very good.
But I'm just trying to think. I'll leave it at this, my lord. If it becomes relevant, you have my submissions on the LCIA points in.
We do,
And it's all about consent, and it's all about, you need our consent, you need the third party consent, and
yep.
you need the
No,
tribunal's consent for it to work as well.
Mr. De Cruz, I want to make it clear, not least for your client's benefit, that we have all of that well in mind. We're not going to ignore anything, and if you wish to emphasise anything, you're not precluded from doing so. But I think what you're saying is that the real battleground between the parties has become, in effect, the weighing up the factors in the exercise of discretion, which is the factors raised under ground 3.
Correct.
Thank you.
May I say something about that? As to the case management aspect of it now, now that the concession has been made, we of course are perfectly content for your lordships to go ahead and re-exercise the discretion. But the difficulty is that your lordships don't have all the material. They've got some of the material, but not all of it, because the judge didn't put the material into a judgment for your lordship. So you've got some of the facts, but you haven't seen all of the evidence. And I don't want to deter your lordships in any way at all, but I don't want to also have a false exercise whereby your lordships are picking up some of the factors from a judgment that didn't deal with them, and then saying, well, this is missing and that's missing, but we haven't got witness statements from below because they're not in the bundles.
Well, what do you invite us to do? Well, in your helpful note from yesterday,
yes,
there was a reference, at least, to the possibility that we would remit.
yes.
But my understanding, I may be wrong, so correct me if I'm wrong. I understood the burden of your note from yesterday to be inviting us to exercise the discretion for ourselves.
I would like your lordships to do that, but I recognise that there are duties to the court, and I wanted the court to appreciate that there is material you haven't seen. The judge didn't have time, let me put it that way, to set out all the relevant facts, and therefore your lordships will be exercising discretion somewhat blind. Now, I don't mind, and I would rather get on because of the nature of the fast-moving litigation in Russia, and I positively invite your lordships to deal with it, doing the best you can. But if your lordships feel they can't or need more material, there are two ways forward. One is to bring before your lordships the material that was before the judge so that you can see it, and that would require an adjournment, but not very, some days. The other is just to get on with it. The third is to remit it to a judge of the commercial court to deal with.
Right. What I would like to do, because I haven't had a chance to discuss this with my colleagues, I would like to rise for 2 minutes so that I can discuss the next steps with my colleagues.
Thank you. I want the Constitution to understand that I'm not trying to put a spanner in the works at all.
I understand. Thank you.
What line is it?
Thank you, that's very helpful. Eddie, can you just write a point down, please? And then write at the end, no, just in the pen, you haven't got time. Pen's the long thing with pointing out. You'll never see that. No, it's,
Excuse me, sorry, do you have a previous one?
I'm sure we could send it to you. Who are you?
All rise in favour?
Eddie, I've got becoming a bit of a thing.
Right, we would like to hear Mr. De Cruz finish his submissions. We don't prejudge at this stage what next steps we'll take, but we would like to conclude those submissions, and then we'll hear you in reply, whatever you wish to draw to our attention in reply.
Thank you, my lord.
Thank you. Mr. De Cruz, on timetable, I know that there was an agreed timetable, but inevitably it's varied somewhat, not least because there was a delay in starting this morning. But I have in mind to give you until 4 o'clock. Is that sufficient? And that would leave some time for a reply if Mr. Lowenstein is content with that.
Thank you. I think it should be
Very good.
famous last words, but I think it should be.
I'll expect you to finish by 4.
Thank you. Well, Lord, I'm going to deal now with the legal principles that relate to what amounts to vexatious or oppressive, certainly as they're relevant to this case. We deal with this in our skeleton. Can I just pick up the most important points? The first is that there is nothing vexatious or oppressive in a foreign claimant seeking to sue in a foreign court to obtain a legitimate advantage that is available in that court and not in the English courts. And one of those legitimate advantages has been recognized, see Star Reefer and Raphael paragraph 4.75. One of those advantages is if the foreign court would be applying its own law to the claim in question. That's relevant here, highly important here, because we are talking about a Russian tort claim. I do not understand how my learned friend was able to argue that that could be governed by English law. Most of his submissions up to below and up to this point is that it is construct, the claim that's being made is one that has been developed through Russian tort law. So Russian law is obviously going to apply to it, not English law. Now, adjunct to that is that see Ocean Connect at tab 15 and paragraph 56. It's legitimate for a foreign claimant to sue in a forum where, and indeed because, the chance of success in that forum is greater than it is in England. Nor is it illegitimate, indeed it is positively sensible, for a foreign claimant to sue in a jurisdiction where there is a chance of receiving practical relief. See Asiana, tab 32, paragraph 104. And as a result, the flip side of the coin is that it would actually be unjust to grant an anti-suit injunction that deprived a foreign claimant of those advantages. And forum fragmentation in itself does not make a claim abroad, or duplicative claim, vexatious or oppressive, particularly in an arbitration context, for all the reasons that I've already alluded to. And as I've said, that disputes involving arbitration clauses are inherently prone to fragmentation, and it is not open to parties to arbitration agreements to then complain when such fragmentation or the risk of such fragmentation materializes. Now, can I just deal then with the 4 reasons? I think it's now become 4 reasons why REDSEC now say that these RRE claims are vexatious or oppressive. And the first is because the underlying transactions are governed by English law. But with respect, that's just a bad point. As I indicated earlier, in the context of a vexatious or oppressive anti-suit injunction application, the issue is whether the dispute that is subject to the foreign proceedings has an overwhelmingly English connection. See Raphael, paragraph 34, sorry, tab 34, paragraph 4.82, page 724. Actually, if we can, it's useful just to have a quick look at that, if you would. Tab 34, page 724. You see exactly how Raphael puts this.
Forgive me, I wrote again.
Tab 34 and page 724, which is paragraph 4.2 of Raphael. Now, what it says here is in Singapore, in the case of the concept of, sorry, my lord, have you got that?
Which paragraph is it?
At the very top of 724, it's
Yeah,
482,
I have,
4.82.
I have that, thank you.
So in Singapore, in case of the concept of sufficient interest has not yet been fully explored. However, sufficient interest may, for example, potentially be provided if the substantive disputes can be characterized as dominantly English in character by reason of the nationality or residence of the parties, the place where their dealings occurred, or the law to which they subjected their dealings. In the RRE claim, that law is Russian law. It is not the contract claim. Claim against the RREs is not in contract. It's in tort. So here you're dealing with nationality and residence of the parties, Russian or Russian subsidiary, the place where their dealings occurred. Now the tort that's asserted in the Russian claims is failure to put into place alternative arrangements in Russia, to facilitate the discharge of the ISA obligation. So the action, the locus of the wrongful conduct by omission is still Russia. And then, of course, is Russian law. So it is not a myopic focus on a contract which happens to feature somewhere in the story that suddenly converts the foreign claim into not just one that's connected with England, it has to be overwhelmingly connected with England. And that description itself indicates that you look at this from a broad perspective, and not just from one single, taking into account one single factor. So it's obvious then that this claim has got no overwhelming connection, the RRE claim has got no overwhelming connection to England. It is overwhelmingly Russian. Adorabella is a Russian company. Perpetia is its Cypriot incorporated subsidiary. The RREs are all Russian companies, Russian delict law, cause of actions in Russia. So in my submission, that first ground for vexatious or oppressive underlying transaction simply goes nowhere. You don't need another inquiry on another day to reach that conclusion.
So if it seems to me you're sort of slightly salami slicing this. We have to look at the broad picture.
Yes.
And the broad picture is that your clients have a clear-cut claim against RENSEC. and that claim is undoubtedly covered by the arbitration agreement, which is a London arbitration, London-seated arbitration. That is the core obligation here, which everyone's concerned with, and your claims, your clients could simply pursue that claim in arbitration under English law in London, as they are obliged to do, and I think you accept that, don't you, before this court. Your clients are contractually obliged to do that. And what's more, you've been injuncted by courts of this jurisdiction from doing anything else. None of that is in dispute, is it? No. So that's the starting point. You are now then seeking to bring parasitic claims against other parties in Russia to enforce that obligation against them, when you could do so against the party primarily liable, as you were obliged to do in London, but you're not bringing it in London, you're bringing it in Russia. Now, looking at that broadly in that way, there's a very close connection to this jurisdiction, isn't there?
My response to that, my lord, is very close connection is not the same as overwhelming connection. That's the first thing. But
Okay,
I would say,
overwhelming connection.
I would say, if you are, the issue here really is how do you balance the Russian connections versus the English connections? And once that balance is undertaken, is the balance overwhelmingly in favour of England?
Don't we assume that you should have done what you should have done? We don't start from the assumption that you've broken the contract and you've breached the court's injunction. We start from the assumption that you should comply with the contract and you should comply with the anti-suit injunction against you. And so the proper position here is you should be pursuing this claim for the return of your investment in a London arbitration. We don't pursue it on the basis, we don't consider it on the basis, on any other basis, do we? So we start from the position that this should now be taking place through a London arbitration. Is that not right?
No, my lord, I have to disagree. There are two issues here. There is the claim against RENSEC.
The claim against RENSEC should be being pursued in a London arbitration.
Yes.
And if that was the case, if you were pursuing RENSEC right now in a London arbitration, would that not be a clear, sufficient, overwhelming connection with your claim against the affiliates or former affiliates of RENSEC for liability in relation to not paying the same non-payment?
No, for two reasons, my lord. The first is that the starting point of that hypothesis is that we are obliged to bring a claim against RENSEC.
No,
If the claim is brought, if
you're
the
not
claim is brought,
obliged to. You're obliged to bring any claim, which you are doing in London. You are bringing a claim, but you should have brought it in London.
a claim against RENSEC, yes,
Yes.
yes. So there are two claims on
And
that.
that's what the starting point is, and we have to consider this on the basis of what you should be doing.
I would characterise it in this way. If we decide to bring a claim against RENSEC, it should be brought in London arbitration.
You
That I
have
accept.
decided to bring a claim against that. You brought it in Russia.
Brought it in Russia, indeed. Now,
Wrongfully.
I accept that. Now, the consequence of that is a choice for my client. It is, you either bring it in England arbitration, English arbitrations, or you don't bring it at all. And they're entitled to that choice. Now, if they decide not to bring that claim against RENSEC, but they have a different option under Russian tort law of bringing a claim against the RRE affiliates, they are entitled to do that. That does not make the claims against the RRE affiliates overwhelmingly English.
Well, not
That-
if not if the purpose of bringing the claims against the affiliates in Russia is to circumvent and undermine their obligation under the arbitration agreement.
I'm sorry, whose obligation, my lord, and what obligation?
Your obligation, your client's obligation
Yes.
to pursue the relief in London arbitration and not to pursue it in Russia.
My response to that is that we are under an obligation to bring a claim against RENSEC in London arbitration, but that does not mean that we are obligated, for the contractual reasons I've discussed, does not mean we're obligated to bring claims against the RRE affiliates in London. There is an avenue for bringing that. The
We're
only
talking about
avenue-
vexatious and oppressive.
Yes. The only avenue for bringing a claim that we have against the RRE affiliates is Russia. Russian tort law recognizes that we're
You do
entitled to.
not need that claim, do you? If you were to sue RENSEC, proceed against RENSEC in London arbitration.
I would respectfully submit that that is not the relevant question.
Because RENSEC have got the assets.
Yes. It's not a question of whether we need to sue one or the other. If my clients
Well,
have,
forgive me, just to say, the reason why it is relevant is because we're looking at whether what you're doing is vexatious and oppressive.
well, I understand, but that's putting the cart before the horse. In some ways, I think we need to see what these two claims are. That's the first thing. Analyze the connection of each, specifically actually just the RRE claims, to Russia on the one hand and England on the other hand. And then in that context, and we're only here, we're not talking about whether or not the claims are vexatious or oppressive. We're talking about whether or not the court has a sufficient interest in granting an anti-suit injunction against the RRE claims, assuming it's vexatious or oppressive. So what I am explaining to your lordship is the limitations of the court's proper exercise of its discretion. I'm not talking at the moment about whether it's vexatious or oppressive. There needs to be an overwhelming connection with England in respect of the RRE claims before your lordships could or should, I respectfully submit, entertain granting an anti-suit injunction for vexatious or oppressive reasons. If your lordships decide that there is an overwhelmingly English connection, separately you go on to ask yourselves, is the RRE claims vexatious or oppressive? We haven't come to that yet. And the question of whether or not there is a significant connection is a discrete issue. It's a discrete issue. You look at what Raphael says. Raphael says you need to look at the dispute between the parties. Here, my clients and the RENSEC affiliates. Look at their nationalities. Look at the governing law of that claim. And ask yourself, where is the connection? Where is the overwhelming connection? Or rather, is the overwhelming connection with England rather than Russia? That's a Russian law claim brought by Russian parties against Russian parties and a Russian subsidiary against Russian parties in the Russian courts based on Russian
I
law.
think I don't want to interrupt your submissions, Mr. De Cruz. It's a matter for you how you present your client's case. But I'm looking again at Raphael, just after the sentence you cited to us.
Yes.
I think the real burden of Mr. Lowenstein's submission is the next sentence. A sufficient connection may also exist if the injunction is necessary to protect the jurisdiction of the English court or English public policy. Now, I know he doesn't abandon the point that you've been majoring on so far, but not only for reasons of time, but also because I want to focus on what this case is really about.
Yeah.
As I understand it, what this case is really about, as my lord has observed, is that you should have brought the claim against RENSEC in London, pursuant to the arbitration agreement. Secondly, you should have complied with the ASIs which have been made by the commercial court. That's concerning Rense. And so what Mr. Lowenstein is really saying is that so far as the claims against the RREs is concerned, there is a sufficient connection with what should be happening, because that is necessary to protect the jurisdiction of the English court, which at the moment is finding its orders are being flouted, or to protect English public policy, which includes the protection of the arbitral process in London, and secondly, public policy in the sense of the United Kingdom's imposition of sanctions. Never mind other countries and the EU. The UK has imposed sanctions. So, speaking for myself, it seems to me that's what is at the heart of it. I know there are other peripheral arguments, but I think that's the heart of this.
Yeah. I don't disagree with you with your lordship, but there is what Raphael identifies here are two distinct gateways
Yes.
to an anti-suit injunction and a single forum case. The first is sufficient interest.
Yes.
The second is public policy. I'm just dealing with sufficient interest. I mean, that's how I read it.
Well, that's fine, but you've got half an hour.
No,
so,
I understand. I understand.
It's a question of how best to use the half hour you've got.
I understand, and thank you for that prompt. But what I would say in response to both your analysis, my lord, and Lord Justice Phillips' analysis, is whilst it is right to say, I don't quibble with it, that any claim against RENSEC by my clients in relation to the ISIS is subject to the arbitration agreement, London Arbitration Agreement. I accept that. That does not mean that my clients are obligated to bring such a claim. It means that if they decide to bring such a claim, that is the forum. My position is that in circumstances where they have a choice of parties to sue, they are entitled to sue the party that they have a better chance of getting payment from. And those are the principles that I identified earlier. And in this case, Russian tort law recognizes that there is a claim to be made against the RRE affiliates. And my clients have made the choice, which they're entitled to, and I'll come to the public policy points in a moment. They're entitled to make the choice. No, we don't want to sue RENSEC in London arbitration. We'd rather sue their affiliates. That does not make, first of all, that does not make the claim against the affiliates overwhelmingly English. It still doesn't.
No, I understand. Yeah. I understand your submission on that.
So can I just? I'm going to come back to the public policy because this is probably the most important one. But I just want to dispose of this idea that it is a collateral attack, which is a separate point I think that's been made. It's a collateral attack on the arbitration agreement or the arbitration process. In circumstances where, assuming that you're with us, that the claims against the RREs do not fall within the arbitration agreement, we say it is counterintuitive then to argue that bringing that claim in the Russian courts is somehow a collateral attack on the arbitration agreement. If you look at the case law that talk about a collateral attack, they actually talk about a collateral attack on the arbitration or the award. And they may refer in conjunction with that to an attack on the arbitration agreement because of the arbitration and because of the award or the effect of the award. But it's not a self-standing concept. And how can it be?
Well, you have agreed that the arbitrators should be the people to decide whether you are entitled to have back the money which is held by RENSEC. And the Russian proceedings are only brought because you are not prepared to put that point to arbitrators or abide by their decision. If you were, you would need the Russian proceedings. So how is that not an attack on the arbitral process?
That same argument, Lord, can be made in relation to any claim brought by a party to an arbitration agreement against a third party in circumstances where that claimant in the foreign proceedings, if I may call it that, has come to a commercial decision that I'd rather go after the third party than after my contracting party in arbitration. That's a perfectly legitimate choice to make. It's not something that could be, certainly not something that could suddenly turn the characterization of a claim to an overwhelmingly English claim, nor in my respectful submission can it be said per se to be vexatious or oppressive.
Well, it's going to depend on all the circumstances, isn't it? Whether it amounts to vexation, just as the categories
Yes.
of abuse aren't
Ye-
closed.
Yes,
so-
yes.
And the vexation of oppression is very much a matter of all the circumstances, isn't it? And
yes.
here we have particularly, you're not just going after another party, you are choosing not to go, not in arbitration, to go after the party who's actually got the investment, and instead, and have determined whether or not they're obliged to repay it to you, notwithstanding sanctions. You're instead going after affiliates who haven't got the investment in a jurisdiction which, because they are the sanctioned jurisdiction, do not recognise the sanctions. In an attempt to get a judgment against affiliates, which it's been said will result in recourse against RENSEC, without the question of the sanctions, which should be determined in arbitration, being determined. And the point that's been put to you, and is being argued by Mr. Lowenstein, is in all the circumstances, that gives a sufficient connection to this jurisdiction and is vexatious and oppressive.
Well, that's two separate points, but in relation to the first point, I'd respectfully submit that none of that can offset, let alone overwhelmingly, the clear connections between the RRE claims and Russia. I'm not going to go through the list again, but you've got the list.
Right.
So it's not an attack on the arbitration process for the reasons I've explained. It's not even, and it's not also an attack, and how could it be, on the Henshaw and Diaz order. It's been expressly considered and determined below, and this has not been challenged. In fact, it was it was eventually advocated by RENSEC at the hearing before His Honour Judge Pelling. That the Diaz and Henshaw order did not cover the RRE claims. It took us a long time to get there, but eventually at that hearing, that was the settled position. Now, in circumstances where those orders do not cover these claims, as has been found by the court, it simply cannot be right to say that pursuing these claims undermines those orders. It just makes no sense. It's not in breach of those orders. That's the end of it.
No, that's the whole point. It's precisely because it's not in terms in breach of those orders. What's really being said is that it undermines the purpose and effect. It circumvents those orders. That's the reason why this dispute is before the court.
Well, the purpose and effect, my lord, of those orders was to uphold a jurisdiction agreement, an arbitration agreement. It was to uphold the obligation of bringing a claim by my clients against RENSEC in London arbitration. Now, if I am right that the arbitration agreement doesn't cover the RRE claims, then it can't follow in my submission that bringing the RRE claims has anything to do with this order. That would be, or undermines it indirectly. The order was very, very specific. It was to uphold the contractual rights and responsibilities arising under the arbitration agreement.
Right.
If, as a matter of contractual interpretation, for all the reasons we've discussed, that agreement doesn't cover the RRE claims, then there's nothing about the RRE claims that undermines those orders and the rationale behind it.
Well, we're talking about sufficient connection.
Yes.
You are going to leave yourself sufficient time to deal with the question of sufficient connection and discretion more generally in relation to the current nature of the argument.
I'm going to come to public policy, and I think that will cover the point.
No, I think what my lord is getting at is also the more recent developments since the judge's order. Change in ownership and things of that sort.
change in ownership.
Yeah, well,
But-
these are your
yeah.
additional. You've raised them.
Yes, I'm sorry.
Skeleton.
Yes,
These
sorry.
are the additional points.
Yes. My additional point.
So,
Right.
so quite apart from.
Yes.
The
I
other
need to leave
matters.
myself time to cover
Yeah.
this. Got it.
Yeah.
Got it. Thank you. Yes. Got it. So, public policy. My broad point, my broad response to this is as follows. It's been said, and really this is the foundation, this is the real foundation of the vexatious or oppressive argument. It's being said that what my clients are involved in is sanctions evasion. To make good that argument specifically, it has to be shown that they're involved in sanctions evasion in relation to the UK. You've seen what we said in our skeleton argument about the fact, and it should be self-explanatory, that it is not the business of this court, with great respect, to monitor compliance with US sanctions or EU sanctions. That has never been.
Is there any authority to that effect?
Well, the authority, my lord, is, for example, what is said in Raphael, which refers to.
Right.
We talked about English public policy.
Yeah, but can I give you another, and you may say irrelevant context, but in fairness, you must be able to deal with it. I can remember when I was in practice, and there were cases arising to do with worldwide terrorism. And the argument was sometimes canvassed that it was nothing to do with United Kingdom public policy, whether somebody might commit a terrorist attack on the United States or another friendly nation. And my recollection is that the English court said, hang on, it's very much part of English public policy to keep an eye on the national security interests of our allies and friends. So why is it obvious that US sanctions or EU sanctions are simply irrelevant to English public policy?
One reason why it is because the US legislative regime has its own mechanism for monitoring its own sanctions and compliance with its own sanctions. And if that is being breached, it's through the US route that remedies should be sought, not through the English route. And then where does one end? What do we mean by international sanctions? What do we mean by Western sanctions? Who falls within? Does Japan fall within the Western sanctions? What about Singapore? They're not Western, but they're all signed up to the same sanctions regime. And when talking about international sanctions, how far does it go? North Korea has sanctions. Russia has sanctions. But obviously we're talking about something which is very specific here. So the only thing that I think that can be legitimate for the court, bearing in mind that you're dealing with a discretion here, is focus on the UK sanctions. But the main point I'm going to make actually applies whether or not one is dealing with UK sanctions, EU sanctions, or anything else. And that is this. My clients are not obligated under UK sanctions. They are not parties that the UK sanctions regulations require compliance from in relation to the respective restrictions in those sanctions. The RRE, they're Russian and they're Cypriot. The RRE affiliates are not bound by the the UK obligations. They are Russian companies. They're not the target of the UK sanctions, nor are they obligers under the UK sanctions regime. That means, I respectfully submit, that nothing my clients are doing in Russia in relation to the RRE claims can properly be described as sanctions evasion. Our case is that at best, that is sanctions avoidance, and there is nothing wrong in sanctions avoidance. Assume for a moment there is a debt, and assume for a moment that there is a debt and the creditor is a sanctioned party. The debtors let's say one is in the UK and the other is in Mexico, for example. And my client, or in a jurisdiction, yes, it's not caught by the UK sanction, and the Russian company then chooses to sue the company, the debtor, that is not caught by UK sanctions. That is sanctions avoidance, and there's nothing improper in that. It's just taking a route which is not complicated or interfered with by a sanctions regime to which you are not an obliger in order to receive payment.
But again, we have to look at the reality here. This is an investment with RENSEC. And RENSEC is obliged to repay your client subject to the sanctions. That's the core obligation here. The claims against the RRE companies are entirely brought because you cannot reclaim directly from RENSEC without having to comply with the arbitration clause.
Yes.
And that's the only reason they're brought.
Yes. But they're brought because Russian law recognises a right.
All of this is based upon, none of this in the anti-suit injunction doesn't in any way challenge the Russian law or jurisdiction. It challenges your client's ability to take this course of action in Russia.
My lord, that's what it would do. The question, of course, is whether or not it would be justifiable to impose that prohibition. And my argument is that it would not be justifiable because what that would be restricting my clients from doing is pursuing a legitimate commercial interest against a party that is able to pay versus a party that is not able to pay.
Yeah, please, you finish.
In circumstances, and that in doing so, my clients are not culpable of anything that could properly be characterized as sanctions evasion. The sanctions don't apply to my clients. They are avoiding the effect of it. It's as simple as that. And that is why we say the public policy argument is not engaged here. It doesn't apply. It's a smokescreen. It's a smokescreen.
Very well. We understand the distinction between evasion and avoidance, and just keep an eye on the clock.
Thank you. In that case, I think the next logical point. May I just check to make sure I don't
Yes, of course.
miss anything important? Can I just give you another example of sanctions avoidance? I know you've got the point, my lord, but I just want to give it some colour.
Yes.
To see how the description of sanctions evasion can be oppressive. Let's suppose you have, for example, a sanctioned Russian party that enters into a contract with a UK party. The contract is governed by English law, but there's no jurisdiction clause. I'm sorry, no, wrong analogy, I think. A contract between Russian party and Hong Kong party, English law, no jurisdiction clause. Suing in the English courts would attract sanctions complications. Suing in the Hong Kong courts wouldn't. Russian sanctioned party chooses to sue in the Hong Kong courts as a result. The complications, I should say, of suing in England would, amongst other things, involve OFSI licenses and the like. You could say, in broad terms, that the choice of suing in Hong Kong is sanctions avoidance. Nothing wrong with that. So I'm just giving you, I mean, there are a few scenarios one can think about. In a supply of goods, you you're supplied goods by a party that's then subject to sanctions obligations that restricts the supply of those goods, UK sanctions obligations, do you then enter into a contract with an alternative supplier that's not beholden to those restrictions? That's sanctions avoidance, it's not sanctions compliance. So, with that, I'll turn to submission, if I may. I think I can make this point reasonably quickly because you've seen our analysis of the procedural motion that broker made in the Capezia claim. You'll recall, my lord, I'll get the skeleton reference for that. You'll recall, my lord, that in that procedural motion, actually, if we can have a look, supplementary bundle 477. I think that's the quickest way of dealing with this.
Four seven seven.
Yes, my lord. I'll take this quite quickly in view of time limitations,
Yes.
but your lordship will obviously have a chance to look at this in more detail. But this is the application to challenge jurisdiction, December the 3rd of last year.
Yes.
You will see at 478, this is the guts of it, the title. I don't know what's it. Oh yes, Renbrock. Renbrock being the broker. Renbrock's liability is subject to an arbitration procedure administered by the Russian Union of Industrialists and Entrepreneurs Arbitration Center. You see that? So there's an analysis of that agreement and the arbitration agreement in particular. Over the page, you will see that the arbitration agreement is quoted in full.
Yes.
From that depository agreement. So we're not talking about the ISIS here, that's the important point. We're talking about a depository agreement. And then there is this phrase, just by the second punch hole on my copy. Moreover, as follows.
Yes.
Moreover, as follows, the clause between the plaintiff and Renaissance, that's Rensec. All disputes between the parties are subject to settlement at the LCIA. Despite this, the plaintiff applied to the Russian courts in violation of the valid arbitration agreement. That is, with respect, if you read it in context, and I'll ask you to do so, that is a sweeping up, throwaway background comment. It is not a basis for the objection of the jurisdiction, and nor can it be because it's talking about disputes between my clients and Rensec, and not disputes between my client and the Rensec affiliates. The point being this, it is absolutely clear when you read in its full context that the challenge to jurisdiction in this motion was confined to an arbitration agreement, a Russian arbitration agreement, if I could call it that, and not this arbitration agreement. So broker did not seek to challenge jurisdiction before the Russian court on the basis of clause 43.2. Therefore, it's submitted. Thereafter, once this challenge was rejected, this narrow challenge to jurisdiction was rejected, it then participated fully in the process, submitted a full defense, and I think there's now judgment in this case. For our purposes, that amounts to submission. That is a distinct reason why we say the Lordship should not exercise your discretion, in addition to all the other reasons that we've identified.
Is submission a bar to an entity's injunction in this type of case?
Would you like to clarify what you mean by in this type of case? It usually is.
Well, it would be if if there is a jurisdiction battle between the two parties, then if one party submits to the foreign jurisdiction, then as it were, that's a very good reason not to. Well, that would
Yes.
mean you wouldn't grant an anti-suit injunction in their favour. But here we're talking about third parties who are not, on this
Yes, I see.
hypothesis,
Yes.
party to the arbitration clause.
Yes.
And they probably have no jurisdiction. They have no basis to challenge jurisdiction in Russia. This is not concerned with them. This is concerned. This is concerned with you. This is concerned
Yes.
with injuncting you from pursuing them in Russia.
Yes.
Why does the fact that they have or have not submitted to the jurisdiction matter in that regard?
Well, I just rely on the general principle. If an anti-suit injunction applicant comes to the English court and seeks to restrain foreign proceedings, and then inconsistently with that proceeds to defend those proceedings, for our purposes, we say reliance on this other arbitration agreement is irrelevant, because it didn't raise the relevant objections that they're raising before your lordship, then that is a reason for.
But the RRE defendants aren't raising objections, are they? It's RENSEC that's raising the objections. I mean, if a party is sued in this,
Yes.
if an English party
Yes.
receives a claim form in this jurisdiction in relation to an English claim, there's no question of submitting to the jurisdiction. It's sued in this jurisdiction. There's no question of it submitting to the jurisdiction. It's been sued here. This court has jurisdiction.
Well, I would submit that a fortiori, if a party comes to the English court seeking an anti-suit injunction in relation to a third party claim, and that third party then at the same time submits to the jurisdiction of the foreign court in relation to that claim, it's even less justifiable.
Well, what jurisdiction? What choice do they have? What could they do? They've
Well-
got no basis to challenge jurisdiction in Russia.
Well, their claim before your lordship is that the RRE claims are covered by the arbitration,
Let's assume that's wrong.
right?
What basis do they have for challenging jurisdiction in Russia?
Well, I rely on it in terms of in response to their application for an anti-suit injunction on the contractual basis.
On the contractual basis?
Yes.
I see. Only on that
Yes.
basis? Right. Very well.
Yes. My last point, I think I've got 2 minutes, is legitimate interest. Legitimate interest in two respects. You got this at the end of our skeleton argument. It's my fault that I've only let myself 2 minutes, but it is an important point. There is no legitimate interest because, as I think Lord Justice Singh identified in this morning, initially, and the goalposts have moved, but initially the claim, the legitimate interest that was relied on by RENSEC was affiliation. So in relation to two of the RREs, by the way that they put their case up to now, that argument in relation to those two RREs goes. As far as
But just pausing there,
yes,
even if that's right, it's said that there's still one which is an affiliate.
yes,
So why, in principle, would it be wrong to grant an ASI, at least in relation to that affiliate?
well, the additional way that it's being put is that there is a contribution claim. And so what we say in relation to that, and this applies to all three. No, this applies to the third. In relation to the third, there is no realistic prospect, and this comes into your discretion. Is the injunction needed to address a realistic risk. There is no realistic risk of a contribution claim being made. And in relation to the two that have been sold, Lord Justice Phillips has the point, because you raised it, and it really was our, we also made it in the Skeleton argument, that you would absolutely expect the sale agreements for those two RREs to address the legal consequence of these proceedings on the change of ownership. We've asked for it. You've seen that. They've said no. Their explanation for that is utterly incredible. They've got the same beneficial owner. It is clear that they are refusing to provide it, trying to stand behind artificial corporate veils, because they do not believe it's going to be helpful to their case. Now, it's been said in response for the first time this morning, well, it can't affect a contribution claim, because it's now being said that it's not possible under Russian law to contract out of the contribution claim. I think that's now the position taken. Well, we've heard over the lunch break that we've been instructed over the lunch break that that's not correct. But it is simply too late for RENSEC to take that point unheralded without any evidence.
It would be a very awkward provision for parties to deal with if you just simply couldn't, in any circumstances, as in dealing with intercompany dealings, contract out of the right of recourse.
It also depends on the governing law of the agreement. So.
But what about the one that is still an affiliate?
Sorry. Right, I see. I'm reminded that RENSEC's own case is that the third RRE is not an affiliate. So forgive me for using that term, but I can give you the reference to that. So I'm told it's page 411 of the supplementary bundle.
Same ultimate beneficial owner, but not a direct
Yes.
subsidiary
Yes.
of their parent company.
Yes,
So supplementary bundle page.
411 I'm told. I think that's Letinovsky 5, but yes it is.
Yeah. Which paragraph?
I'm just finding that.
Yeah, I've highlighted it, I think.
Oh, it's
So it's the two places to go.
Yes.
411.
Yes.
Letinovsky 5.
yes. Which
Paragraph 79.
Paragraph 79. That just says, sorry, that just says 79, Douglas.
It's really 81, isn't it?
Let me just check that, my lord.
Yeah.
We're not a single decision maker. Yeah. Yes, we rely on 79, 81, and also page 267, I'm told. And that is credit's defense. That is credit's defense in the Russian proceedings, which I'm told asserts that it is not an affiliate.
Right.
It's not part of the RENSEC group. Yes.
So,
It said there, accordingly, that the bank has nothing to do with the Renaissance Capital Group. It cannot have anything to do with the Renaissance Capital
Yeah.
Group. So the point being is that in the Russian proceedings, they are actively distancing themselves as affiliates, no doubt to avoid the tort implications.
Yeah. Can I just take you back, Mr. De Cruz, to page 411 to make sure that I've understood it correctly, and so Mr. Lowenstein knows what it is that he has to deal with in reply. Is this right that the evidence filed by the appellant is to this effect? Paragraph 81.1. RENSEC's UBO is, and since the earliest date of execution of the ISAs has been Mr. Prokhorov. 81.2. From that date until the 13th of November 2024, he was also the UBA of all three RREs. And
Correct. And then 81.3, I think, is the critical one.
exactly, that he remains the ultimate beneficial owner of one of the RRIs. And what is then said, as I understand it, particularly at 81.4 paragraph C, is that RCFC and RB were sold to people whose identities are unknown to RENSEC,
Yes.
even though it's Mr. Prokhorov who's been the UBO at all material times.
But that's why it's completely incredible. It defies belief. And indeed, I'm trying to find it.
Before we leave the statement, this is a witness who's filed a statement in the courts of this country. And can I just be clear, is it part of your submission that he had an obligation of candor to this court
Absolutely.
to explain what on earth was going on
Yes.
in that sale agreement?
Yes, absolutely. And we've written, my instructing solicitors have written to RENSEC solicitors, Candy, asking for the sale agreement. So this is not just coming from Mr. Lesinovsky. We've been told it's not relevant. You can't, it's not relevant.
I see.
And I think it's been said we don't have a copy. To be fair, I think it's been said we don't have a copy. But
Yes.
clearly that's because they don't want a copy.
Yes, Mr. Richard Cruz, I've taken you over your allotted
Yes.
time limit.
Yes.
We must leave enough time for
Yes.
Mr. Lowenstein to reply. Can I
Yes.
just check if there's anything else that you absolutely need to say?
Yeah, well, you've got how the candor point plays into discretion.
Yes.
You've seen our authority about how incredibly slow the court should be, taking into account all the other considerations. If in addition to that, you're not being provided with the full picture as to whether or not the claimant has a legitimate interest in seeking the anti-suit injunction, particularly here in a single forum context.
So which is the authority you're referring to there? Don't take us to it, but just tell us what it is.
Donahue, paragraph 16, I'm told.
Thank you.
Thank
Right, may I just check if my lords have any other questions? No, I'm sorry.
Can I just one further thing in terms of we don't know who the companies have been sold to. I will get it to you, but there is an article in the supplementary bundle which identifies the specific individuals who bought it. So
Right.
Again, lack of candor, I'm afraid.
Right, thank you very much. Can I just check if you wish to add anything?
My lord, no, subject to just getting that reference for my leader.
I'm very grateful to you. Thank you very much. Yes, Mr. Lowenstein,
Might I just have one moment, my
of
lord?
course.
Yeah. 272. Page 272, just to.
Sorry, page 27.
272 of the supplemental bundle.
Thank you very much.
Lord, I had thought that I was going to have to deal at some length with the first grant.
Yes,
But there's now been a complete concession on that, because learned friend accepted that as a matter of law, in a single forum case, it is possible for the court nonetheless to go on and grant an anti-suit injunction on the vexatious and oppressive basis. So he does not support the I'm just wondering whether I should wait, as Lord Justice Males is looking for something.
No, the bundle's collapsed completely on me, so
sorry.
Sorry, can we help?
I don't think
can
time
we
is
put
going
it
to
back
help.
together again, or?
Well, you carry on with us.
Thank you. I often have the same problem.
No, that was your interpretation when you opened that was their position.
Yes.
So there's nothing new there.
Nothing new, except what I said was that they weren't supporting the judge, yet they have sought to contest ground one and only gave up under close questioning, let's put it that way. It doesn't matter, we're not talking about costs now, we're just saying that I could start in a different place. So what is the law on the point that a learned friend laboured, which with respect to him, on the overwhelming connection point. He kept saying this word, and then the point that I put to you now. Oddly, we keep hearing it from Mr. Raphael's book, and although he's a very good chap and very learned, the better place to go for this is to Airbus, where Lord Gough puts these propositions, and then we can see how they come about. Now, the references are as follows. I gave them earlier, but I will hopefully now take your lordships through it. So could we go to Authorities 6, starting at page, I think, 99. Your lordships will have read this section already.
Yes.
It starting in the judgment at the bottom of the page, comity.
Yeah.
Lord Gough explains that a respect for comity requires that, see between G and H, that the English forum should have a significant interest in, and the connector there is or, not and. My learned friend said it had to be and, it's or. Connection with the matter in question to justify the indirect interference with the foreign court which an anti-suit injunction entails. So that's the starting point.
Yes.
2, we know, and so I won't develop, that there is a different approach in alternative forum and single forum cases.
Yes.
But now I'm focusing on single forum cases.
Yes.
I won't trouble you again with alternative. So the single forum case analysis is on the next page 100.
Yes.
And it starts between F and G, and this is where the language comes from. In a single forum case, this approach, as I have pointed out, can have no application. So that's the submission I made earlier. It just makes no logical sense to look for another one. In such a case, it may, however, be possible. It may, however, be possible to establish a sufficient connection with the English forum. In particular, this may, as Midland Bank suggests, involve consideration of the extent to which the relevant transactions are connected with the English jurisdiction, or it may be, as Judge Wilkie's statement of principle in the American case of Laker suggests, involve consideration of the question whether an injunction is required to protect the policies of the English forum. The word overwhelming doesn't appear. Now, learned friend will want to try to read in the language from elsewhere, but what we say is, first of all, so the stratified submissions are these. 1, overwhelming isn't there. 2, even if it can be read across from somewhere else in the judgment, it doesn't limit in any way at all the discretionary provisions which are at play when one looks at the consideration of the question of whether an injunction is required to protect the policies of the English forum. Because learned friend submissions were that the overwhelming limitation is a limiter to the jurisdictional nexus for the connection, the character of the claims. So,
Before you leave the,
I'm not going away, actually, yes, but my lord, yes, your lordship.
well, we need to note that on 140, especially on that C, he goes on to say, I'm anxious that the principle should not be interpreted too rigidly.
Yes. I'm anxious that the principle I've stated should not be interpreted too rigidly. I therefore expressed it as a general rule. That was something I said earlier, but didn't read from the. And then going on between C, just above D. Indeed, there may be in the extreme case, and that's where we pick up the extreme case.
Yes.
For example, and that's the excess of respect normally required. Now, learned friend Skeleton dealt with this at paragraph 17. And he referred to authorities page 100, so that's why I've gone there. And he said this, it, quote, may ellipsis be possible. I'm sorry, I'm not trying to construe it, I'm just trying to say what his submission was. It may be possible to establish a sufficient interest in single forum cases if the transaction that is the subject of the foreign proceedings is, emphasis, overwhelmingly English in character, or if an ASI is required to protect the policies of the English forum. And he gives Airbus 139F2G.
Yes.
That was his submission. So the overwhelmingly English or English in character is just one of the ways of establishing the connection. Your lordships already have the rest, and the other is the protection of the policies. Now, Mr. Raphael's book, if we're going to go to that, can we go to Mr. Raphael at 4.93, who deals with this? I'll just pull that up. It's 726. It's tab 34, 726, 4.93. And this is illuminating. He's talking here about alternative forum cases, but I place particular emphasis on about the sixth line at the end onwards. Lord Gough rephrased the point, because even there isn't a hard rule. General requirement of sufficient interest can be satisfied in other ways. And it goes so far at the end to say, so for example, the English court is the natural forum to grant the injunctions to protect the English arbitrations. Should not matter if it would not be able itself to hear the matter submitted to arbitration. That's been the premise of everything today. No one's saying it should come to court. However, in classic alternative forum situations, where an injunction is sought on the V&O basis, the question of natural forum will be a central consideration. So in case helpful, I just put that before you, but we say that this is a single forum.
Yes.
Now, why are the claims vexatious and oppressive? And we dealt with that in our skeleton at paragraphs 51 and thereafter. I don't want to in any way go back to read them out, but I didn't develop the points in any detail at all before, but I will just perhaps remind the court of what we said as headlines. So first of all, those claims, the RRE claims, are vexatious and oppressive because they seek to obtain the illegitimate advantage through the pursuit of foreign proceedings to evade the impact of sanctions. And we rely on that, for that, on another decision of the same first instance judge,
Yes.
Softcom Bank. Your lordships will have seen it.
Yes,
I'll
I
just
read
give
it.
the reference, because we set it out at 2214 in our skeleton. It's authorities 31, 606 at 612. Softcom Bank at paragraph 25. It's the obtaining of the illegitimate juridical advantage.
Yes.
And then you see what we say at 51. If you just look through 51, please, just to remind yourselves of the points we make there. And the references, when you come to them in Deutsche Bank, Highland Crusader, are at paragraphs 50, subparagraphs 4 and 5, authorities 12.223 at 236, and 56 to 61, pages 238 to 9, citing Airbus, paragraphs 57 to 61, and Barclays Bank and Homan, authorities 53 at 59 to 61. First instance, Mr. Justice Hoffman, as he then was, but undisturbed on appeal. So those are the references there. Now, to, as it were, push home the point, we respectfully support, and would wish to add a point or two more, some of the points made by my Lord Justice Phillips to my learned friend in his questioning of him. The broad picture does need to be looked at, and that's what the authority said. It was a part of my earlier submissions. One doesn't look at the form, one looks at the substance of what is being done in the foreign jurisdictions, Mr. Justice Bryan in Qingdao and elsewhere. And secondly, one needs to look at all the circumstances of the case. And then there is the point which the court has, and therefore I will deal with very quickly, and that is the fundamental point that I have been making, I think, all day. Lord Justice Phillips put it to my learned friend, is that the defendants are contractually obliged to sue my client in arbitration in London in relation not only to the contract claims, but also in relation to any tort claims related to the contract. Had they done, as I said this morning, and Lord Justice Phillips said the same earlier, had they done what they were bound to do, there would be extant LCIA positive proceedings already underway in London against my client, and there would be no proceedings against my client in the courts of Russia. But they didn't. And that, I'm sorry.
There might be an award by now.
Oh yes, there would have been an award. Well, there certainly would have been some sort of interim award by now. And the issues would have been dealt with, because it's not a very long point that the arbitrators would have been dealing with. My clients have, and it's in the judge's judgment, accepted that absent sanctions, they would be returning the assets. So the only issue is a point of fact relating to the sanction status of the various parties involved, and the impact of sanctions by way of defences. And these are not the only claims that arbitrators are dealing with, to my certain knowledge, of this nature. So had they done what they were supposed to have done, learned friend accepted that my clients should have, this is the most striking part of this case, is that he accepted in open court that his clients have breached the arbitration agreements. They should have been sued here, and he also accepted, I think, that they were in breach of the anti-suit injunctions in continuing in Russia. But nonetheless, they seek to take the illegitimate juridical advantage of then trying to load the Russian proceedings with the third-party claims to make my clients jointly and severally liable. So in the counterfactual world, where there is today an action in England brought by 6 claimants, so it would be 6 arbitrations or 1 consolidated arbitration, that's the counterfactual world. The question is where we all would stand, and where we would stand is that there would be no claim against my client in Russia at all, and the RRE claims could be brought under the rules up there. Learned friend says that Russian law would apply. We would say argue to the RRE claims. We say not. We say under the English rules of conflicts of laws, it is much more likely that the arbitrators would apply English law to those claims because of their close connection to the contractual claims. It's a matter of debate, but we say it is much more likely than not, in which case the sanctions regime would apply. I'm almost done. Learned friend, forgive me. Yes, on submission, learned friend made his submission, points about submission. The evidence in response, I reserved on this earlier, on the evidence in response is Lutinovsky 5, paragraph 30 and following.
Yeah.
He makes clear that there's been no submission. Of course, as the court put to my learned friend, I think it was Lord Justice Phillips, my client is not said to have submitted. It is the RREs who are said to have submitted, but that is disputed by my client as a matter of law, and they've gone to length to set out the legal status of what happened, precisely what happened. He was there or received reports, and he gives his analysis, which he says amounts to no submission. But more importantly, I think the court asked whether there's any law on whether or not submission is a bar to a grant of an anti-suit injunction, and indeed there is, and it's a judgment of my Lord Justice Mayles. In SAS and WPL, you dealt with exactly this point. Could you just turn briefly, and this is a strong, your Lordship was looking at whether or not submission by the party itself, not by the third party, so the contracting party, meant that there was a bar to an anti-suit injunction. The reference is Authorities 28, 574, I believe. So this is SAS, and it's after the section on comity. There's a heading submission and delay. My Lord examined whether or not arguments about submission to the foreign court could be a bar to the anti-suit relief that was being sought, and the conclusion was that it isn't a firm bar. The circumstances of the case need to be looked at and taken into account.
Sorry, can I just have the paragraph number
Yes, of
again?
course, my lord. It's paragraph 113 is where the section starts, with the conclusion at 117.
Thank you very much.
And then, my lord, deals very happily with the approach of an appellate court starting at 118 and looks at star roofers and so what should happen if the Court of Appeal disagrees. So on submission, first of all, so the points in turn are the evidence I've identified. The evidence says that the RREs haven't submitted. Certainly my client hasn't submitted. We've set out the law. Now, one or two important points that follow from that, and then I will finish. First of all, the respondents do not anywhere say that the RREs have submitted as a matter of Russian law. Learned friend puts an English law complexion on events in a Russian court. My clients have put the Russian law complexion on what happened in the Russian court. And Mr. Lutinovsky at paragraphs 29 and 32 explains how the RREs have in fact variously objected to the jurisdiction of the Russian court. And we make them make weight points as well, and take from them what you will, that they have given their consent to LCA arbitration.
Yes.
And Google, the recent decision of Justice Hemshaw, deals with question of submission in the context of anti-enforcement injunctions at paragraph 111, Authorities 33717. Lord, unless your lordships wish any more
Yes.
on the question of legitimate interest, which was the other new point,
Yes.
I think I've said enough about that. And if there's anything
We would like your help on the point I raised with
Yes.
Mr. Cruz in supplementary bundle at page 411,
yes.
and in particular paragraphs 79 to 81 of the fifth witness statement.
Yes.
Is there anything else that you wish to say? Because I have to say, speaking for myself, I do not regard that as a candid account to this court.
Yes, well, Lord, I can't go behind the evidence. It is the evidence that
It is.
is available to me to
Indeed.
put before the court. What I would say is one needs to start from the position of asking why the evidence matters at all, because what we say is it wouldn't matter whether the RREs were, as we said before the judge, affiliated or not affiliated, because the only thing that matters is the claims that are being brought against them.
Yeah.
And so your lordship, even if your lordship, as he puts it to me, has a point, and even if the position is, as my learned friend put it, murky, that's the word he used in his skeleton,
Yes.
I've read it, I apologise for that if that's the case, but it doesn't change the result. It's not that anybody, if the court is not being given all the information, it doesn't matter. Here is the best I can say about it, and it doesn't matter because the nature of the claims are that they are being sued for what they are, not what they actually are.
So not what they actually.
So they're being sued
Yes.
because they've got the same name.
Yeah.
They're not being sued because they are. It said that they're in the same group, and that's why they're being sued. So the result is that nobody, for example, has withdrawn the Russian claims because of the sale.
Thank you very much. Can I just check if my lords have any other questions for you? Well, I'm grateful to all concerned, not only those who have addressed us, because we understand how much work goes into the preparation of these hearings. We will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible. And if they can't, file written submissions so that an order can be finalised at the same time as hand down. Circulation to the parties or to any other person for the purposes identified in the Counsel General for Wales case will be the responsibility of solicitors. Any such circulation is for those purposes only, and any other publication may be a contempt of court. Unless there's anything else, that brings us.
May I
Yes,
just
Mr.
mention
Blackstone.
the interim relief that's in place
Yes,
at the moment?
yes, of course.
Lord Justice Lewison's order, which is in the main bundle at tab 12,
Yes.
makes an injunction that requires certain facts so requires certain things not to be done
Yes.
and requires other things to be done.
Yes.
I should have, but I haven't checked whether it expires, as it were, after today. But would your lordships extend that order until after judgment?
Well, it hasn't been suggested to us so far that it should not be extended until judgment. Do you want to say anything about that?
May I take very brief instructions on that?
Very brief, yes, because we are now 5 minutes over the allotted time.
Stands for final determination.
Which page is that?
I think it may be.
159.
Yeah.
As a matter of caution, I should say that we would need instructions from our lawyers in Moscow. I'm not pursuing any formal objection.
No.
I'm just saying
No.
I don't think I can
Very well.
positively consent.
The
Well,
expression at the moment is the pending determination of the appeal. I think,
Exactly, yes,
Lord Justice
yes.
said that to me. It's just that the language is slightly open, but it hasn't been determined.
No, it hasn't.
It's only
No.
been heard.
No, I'll make it clear if it needs to be clarified that the current injunction continues in place until judgment is handed down and a further order of the court is issued.
Thank you.
The order, as is conventional, already contains a liberty to apply clause, and so if anyone wants to have any other kind of order, they always have that liberty. That protects everyone, I think.
Yes, my lord. With your lordship's recorded views on it, I think it would be a brave person to
Very good.
say otherwise.
And we know that a transcript has been made of this hearing today. So really anyone who's interested in this case can have no reasonable doubt about what has been said.
You can even watch it on YouTube, apparently.
Indeed. Thank you all very much.
All rise, please.